Hi, my name is Caroline Shields and I'm the head of the Court of Protection team at Park Square Barristers, a multidisciplinary chambers in Leeds. I'm also an experienced family practitioner and I'm going to be talking to you about deprivation of liberty of young people, those people aged 16 and 17 years in both the Family Court and the Court of Protection under the Mental Capacity Act. By way of an introduction, I've provided a list of questions there, essentially hopefully for me to answer, but also for you to address as we move through the seminar. The first being, what is a deprivation of liberty? What are the circumstances giving rise to the need to authorise a deprivation of liberty relating to a child or a young person? Ultimately, why do you need to seek a deprivation of liberty authorisation? What are the legal mechanisms for doing that in relation to a child or young person? And what are the differences between the two main authorisations that I'll be considering today? Firstly, in relation to the inherent jurisdiction of the High Court and the Family Division, and then also in relation to the Court of Protection, which can authorise deprivations of liberties for those over 16 and into adulthood who lack capacity. Finally, what steps ought to be taken to support a child as he or she transitions into adulthood by public bodies that can be provided as useful information for you to consider after the seminar. So moving to the first slide really, and the question of what is a deprivation of liberty. Article 5 of the European Convention of Human Rights is the right to liberty and security. And at paragraph 1, it sets out that everyone has a right to liberty and security of the person, but then goes on to provide some exemptions to that as follows, and is relevant to this discussion. It says no one shall be deprived of his liberty save in the following cases and in accordance with a procedure prescribed by law, and that's what we'll be considering later in the seminar. The two relevant categories here are the detention of a minor by lawful order for the purpose of educational supervision, and then also the lawful detention of persons of unsound mind. So I've highlighted those two parts there.